Hello and welcome to the Domestic Relations Practice Section meeting. I'm Caitlin with the Fayette County Bar Association. Just a couple of housekeeping things. If you have questions, please use the Q&A function at the bottom of the screen. It's easier to keep up with. The chat can go by kind of fast, so please use the Q&A. Handouts and the CLE sheet can be found on the website. It's just on this event's calendar page. I'll also post the handouts in the chat section as well. And that's all I have, so I'm going to turn it over to Lindsay.
Thank you everyone for tuning in, and especially a huge thanks to our two presenters today. It's my pleasure to introduce them to you all, although I'd guess that almost everyone on this Zoom has had the pleasure of working with both of these fine mediators. Of course, you all know Patience Jazdzewski. She is the director of the Mediation Center of Kentucky, former family law attorney, so she brings that to the mix with great experience. Many of you have probably had the pleasure of working with her, and I'm sure also you are familiar with and friends with Valerie Kershaw. Valerie is the senior partner of the practice Kershaw and Baumgardner. She is also an incredibly distinguished academic and AAML fellow, and the former chair of the Fayette County Bar Association Domestic Relations Section. And she's been a mediator for many years. She also brings great expertise to her work. And I've had the pleasure of having both of these women mediate cases for me that I thought could never settle. And we walked out the door with marching orders and ways to get things done. So I hope today they'll be able to bring some insight and clarity and guidance to us so we as practitioners can better utilize their services. Without any further ado, our presenters, Valerie and Patience. Thank you, ladies.
Thank you. We're glad to join you today and look forward to questions. So at any time that people have questions, feel free to submit them. And I guess from there, we'll just get started. So let's start with why you all want to mediate. You have many options available to you. Obviously, there's litigation. I believe there's arbitration available to you, and of course, mediation. I think mediation is a very effective tool. It allows privacy for the clients. Certainly, anything you can resolve in mediation, I think the parties move on forward with their agreements, things that they can agree upon. It might not be everything that they wish, but they can live with it. And I think we have all been in front of a judge where the mom wants A and the dad wants B, and the judge gives you X, Y, and Z. So they have control of this process. I think that's a big thing, is that a lot of times family law, we have the confines of where we know it's going to go, but we don't know what's going to work for any particular family. And who better to decide that? Yes, they need to be informed, and that's what mediation's all about, making sure everyone has all the information necessary to make an informed decision, but then really pressing them to do it, because we know, especially when there's children involved, who better to raise the children than the parents that had the children. And so that doesn't necessarily happen when you go to court over and over and over again. Sometimes the judge might feel like they're raising them, and this allows the parties to have some control in the outcome. And I think in mediation you also have the ability to dig in a little bit deeper. You know, we don't have as much time as we would like, but to sort of get to why the parents in particular, when you have children, are in such conflict. And perhaps if you can assist the parties in trying to communicate better in the future, that's a tool they can use forever. Of course, that's not going to happen in court. Right. And sometimes, you know, if they start the mediation, and we talk about this about as far as when's appropriate, if they start with the format that this is a way we can work together as parents outside of the husband-wife that is terminated, it lays down a foundation. And that foundation can be built upon, whereas if you're always just going to court to have fires put out, you're not learning any fire prevention, for lack of a better phrase, kind of thing.
I think that's right.
All right, so that's good on why to mediate. Let's talk a little bit about selecting a mediator, because that is really an important step. You need to know your clients. and hear them as far as what their interests are. You know, you're there as their advocate to counsel them on the law, but you also have to counsel them a lot on the process, because picking out the mediator, pick out someone that you think is going to either be able to hear your client well, because not everyone can. So there's an approachability standpoint. And they should be very well versed in family law issues. And if they're not, it shows.
I agree. I think, you know, there are a couple mediators in town who mainly do personal injury cases and other financial cases, construction cases, and they're great mediators. But sometimes you need a little bit more than just the nuts and bolts of a financial mediator. Again, you have a history, even if it's only a financial case. These two parties have a history with each other. And sometimes when you have a client who might be giving up a whole lot of stuff, and you're like, why are you doing this? And they're like, you know, basically, I got my reasons. You know, we're not living these parties' lives, right?
Right.
And there's a lot of history there. And even if they're not in conflict over the children, these two people might want a relationship of some kind going forward, either co-parenting or just be able to go, you know, to a restaurant in town and be able to say hello peacefully.
Because there are several mediations that come in that don't have children, and they're still part of a community. And if they've been married 5, 10, 15 years, they have the same circle of friends. They may have the same, you know, social, church, financial, and they need to be able to work through that without having to, you know, shun the other person and run the other way for the next 30 years of their life. And so that does take a different, you have to at least appreciate that that's going on, which is different than, you know, our general mediations. They don't necessarily need to be in the same room because they aren't going to have that continued relationship, or we don't focus as much as the relationship. But with or without children, I think whatever mediator you choose has to be on their horizon, kind of thing.
I think that's right, because both patients and I do non-family mediations as well. I don't do very many, but it is a completely different dynamic. You know, this guy wants $10,000 and this guy wants $100,000. And, you know, basically we're just working toward a number, right? They're never going to see each other. These people definitely have a history, and they're probably going to have a future. And that takes a lot of understanding of personalities. As I say, I'm not a therapist, but I play one in my job, right? And, you know, we just see a lot, and you can kind of understand the dynamic that's going on. And I think it's nice for your mediator to kind of get a clue into how the dynamic and the family's working. It helps settle the case, I think.
Oh, I think so too. I mean, I think that the ability of the mediator to kind of hone in on what's going on and just kind of take it for what it's worth, but hit those cues and kind of understand. It's pretty quick that you can kind of see dynamics develop on how they communicate, and, oh, maybe this is why they're here, type of thing. And if you don't have that, it's going to take you a lot longer to get to the point where we're actually making progress and trying to resolve it. And I think another thing about picking a mediator, you've got to keep in mind what stage you are in the process too, because there are some things, if you're just working on a Band-Aid to get somewhere, it may look different than if you're trying to sit down for the full-fledged global, let's nail every piece down. Don't you think?
I do too. And I also think too, when you're picking a mediator, kind of getting off that going a different tack, every mediator has a different style, right? And honestly, we are so lucky in Fayette County to have patients, which is why she's booked so far in advance. I think she's the best mediator we have. And everyone wants to hit patients first. I tend to be a mediator who will challenge each party on their position. Obviously, we can't make a decision. Obviously, I can't say what a judge will do, but I certainly can say, well, what if the judge thinks your position is X? What if the judge finds that this is a problem over here? I do challenge people. And I think mediators want to get a case settled. That's what we're there for. And we do try to settle the case. some mediators are a lot more laid back. And that might work well. You know, we used to have a great mediator, Mitch Cherney, out of Louisville. Unfortunately, he died a few years ago. But when I had like a guy who was a jerk, who knew everything there was to know, an attorney, for example, or a judge or a doctor, oh my gosh, Mitch Cherney was the man. He would just stare him down and say, look, you know, you're being stupid. I mean, he was just flat out, just say it right out. But he could get that particular client to listen to him, and he was a great resource. So, you know, there's mediators across the state now more than ever. Next month I'm using a mediator in Northern Kentucky because the opposing counsel is in Northern Kentucky. The opposing counsel doesn't do mainly family law, but he really respects the family law attorney who's going to be doing the mediation. Mm-hmm. So he's going to listen to that mediator a whole lot more than someone he doesn't know in Fayette County. And because we're Zooming, and it's a Fayette County case, but because we're Zooming, I'm like, great, I'm going to use this guy. He's going to believe him. Also, the opposing party was concerned that everyone in Fayette County knows my client. I didn't know my client, you know, that everyone thinks that, right? You know, but so they can't possibly have a non-biased mediation in Fayette County. So that was a good choice for that case.
Right. And I think the other part is it should be collaborative between both attorneys. And, you know, when you're picking a mediator, listen to one another as far as throwing names out there. And I think style is a big part of it. I know, you know, Valerie's such a wallflower. I'm just that, you know, that making everyone say, okay, wait a minute, stop and listen to it. It's a little different than maybe some of the laid back ones might not be. You might not get much traction if your clients are really laid back also. So you do have to kind of keep it all in mind and think, you know, what is the best fit for this case?
Yeah, that's right. And, you know, the other day I had some people in and it was it was post-decree custodial issue. And mom was being, I don't remember, I think a little overprotective, and I was kind of getting on her. And then dad said something and I got on him, and he kind of looked at me and I said, look, I just got on her. Right. And now it's your turn. Right. So, because, you know, I don't have an opinion. So again, you know, it depends on what your clients need.
But I think that's a good segue into preparing your client, because I think that is huge and feel very strongly about it. You need to know your client enough to know what they need. Sometimes, and it's very embarrassing when this happens, but sometimes in a mediation, it becomes very clear that the client and the attorney are not on the same page. And it may be the attorney knows that they can get, let's just do timeshare. You can, you know, unless there's huge problems, they're like, you can get 50-50. Well, if this is an established family and the way something works and considering everybody's work schedules, etc., the client's like, well, what I really want is maybe just shy of it because that client's not counting hours. Yay for that person. But the attorney and the client haven't had that preparation to really identify what are your needs, what are your interests, what do we hope to accomplish. And I think that's a big part of when there's children involved. And another thing that we talked about when there isn't, there's financials, you've got to have your financial disclosures. If you have an all real estate case and you come and you don't have appraisals and you don't have an agreement as to what the fair market value is, you're wasting everyone's time and money. And for me, the more prepared everyone is in coming in, the more they're going to get bang for their buck.
I think that's right. And as far as preparing, sometimes you want to use the mediation early on to say, we have 15 major issues. How are we going to tackle these? Mm-hmm. Are we going to get joint appraisers? Are we going to, you know, sometimes on a large financial case or a large case, you may do a couple mediations, right? Just so we agree that this is this process. We're going to go for a couple hours, see patients. We're all going to agree how to get these things done, and then we'll be back in a month. So that is a way to use mediation. Clearly, that can work.
But you need to have told your client that, because sometimes, and in bigger cases, I've had that happen a lot. But if we're coming in for like basically a work schedule and try to figure out what are we going to do, what's the timeline for getting these business valuated, what's timeline for this, and then but the client's like, well, I just don't think we got anything done. And the attorneys are like, we got tons done. We have a follow-up date but in that client's mind, what that tells me is that attorney didn't really say, okay, first step is this. We need to come up with a game plan and, establish who's going to do what, when, and where, and then we can get to the next step. And had they known that, they might have felt like, oh, okay, we're making headway.
Yeah, right. And I've also sometimes, I've done this with patients when we have very large financial cases that have a lot of tentacles on them. Opposing counsel and I and patients, we meet together maybe the day before for an hour or two and say, here's my spreadsheet, here's her spreadsheet. This is where we are, and this is where we're apart. Let me catch you up to speed, because I don't need the clients to explain the 15 major assets we're trying to figure out and what the valuation problems are. So the attorneys spend a little bit of time together with patients, then everybody's ready to hit the ground running with the clients at the mediation. So I've used patients in that way.
Right. And I think that part of the preparedness is what is your goal for that session? And then really having that sit down to understand. I mean, if it's okay, maybe we're going to take this part one, we're going to do the child issues because there's a lot going on. Well, once, make sure that they're on board with that too, that you're both, of like mind as far as what you're going to get accomplished. And there again, it doesn't hurt if you've exchanged offers before you come. Please let the mediator know, because there again, this is a huge opportunity to waste time and money, and that's frustrating. I mean, it would be frustrating to me if I was the individual that was the client. I'd be like, wait a minute. So we backtracked and they'll come in and say, this is our offer. Well, what they didn't tell me is that was their offer 4 weeks ago, and then they got a counter that said no. Just even if you don't want to start there, let the mediator know and prepared, and so your client knows too. This, even though we've made this exchange of offers and counters, this is where we're starting today, because that will help shape how we go forward.
That's right. And I also think that if you send the mediator, it can be ex parte, your client's positions. Certainly it's nice to have the PVDS if they want to do that. Kind of tell the mediator where you are. Oftentimes I will send the mediator, typically patients, this is the offer, this is the counter, and here's where we're apart. I think we can start here. Or I've made an offer. Why don't you just start with them? Sometimes I don't need to come at 9 o'clock if I've done all the work and I've gotten crickets on the other side, right? And patients can say, okay, I understand this is the offer. Where are you? There's nothing worse. These clients are paying 2 attorneys a whole bunch of money, and they're paying you a whole bunch of, paying patients a whole bunch of money. And then they've all left their jobs for the day. And just to get there, I often am frustrated, like, why didn't they talk to their client about this beforehand? They knew where we were. Why does my client have to pay me an hourly rate to sit here while they're looking at the offer I sent them 4 weeks ago? And that goes into picking your mediator as well. You want to pick a mediator that'll help you get successful, because you're like, well, it's just mediation. If we don't settle, that's okay. They've spent a lot of money for that day. You really want to get them through the day.
Well, I think so too. And I think the other part about that is not only the money, but when they're being prepared and they have to realize that this is what we're going to do. We're going to go in there. The mediator is going to hear what you have to say, hear what the other side is, but you also have to be open. And I think this is a good thing to help them prepare too, is that you already, you've ascertained where you are and they know that process, but they are also knowing that part of what the mediator is going to do is try to have them look from a different point of view, because sometimes sometimes clients don't like that. And as kind and soft-spoken as I am, sometimes I get a little, you get pushback when they're like, oh, well, that's not what, and they have to be willing to kind of look at it from a different side and understand that that's part of the mediation process. That's not part of necessarily the trial process where you're just trying to, you know, bulldoze over and prove to the other side, you know, prove to the judge that your side's more reasonable, et cetera, within the law, blah, blah, blah. But this is just different. And I have noticed over the years that some people are taken back by that part, where you say, oh, okay, so I heard this, and then you either ask a question because it's something that they both left a hole in. And then when you ask it, they don't know how to respond because they're so used to, because all they've done with their attorney has looked at it one side, one side, one side. Give them the benefit of having a little devil's advocate in you, a little, not, you know, in the mediation session, but before you get there, just to say, hey, this could be looked at other ways. And I think certain attorneys, they do that, and it really pays off because it at least plants that seed that, okay, I might need to check my beliefs and how I'm viewing my own case. And if attorneys don't do that in preparation, it shows, because then it's just staunch. This is where I am. I'm not moving.
Right.
Because they're invested in kind of that,
Yes.
you know.
Now let me just ask you guys, Lindsay, do you want to do any questions before in the middle, or do you want me to keep going? Are there any?
There are no questions in the chat box yet, so if you'll just keep going, it's great. Thank you.
Okay, so
We can talk forever.
we can clearly that goes without saying. Okay, so I do want to also say to you, now that you've chosen your mediator, and I know this in particular with younger attorneys or attorneys who don't do family law a lot, they might have said to their client, look, I know you don't ever want the father to see these children, but they're going to. And then they're in there and like, I don't, you know, basically this client is like, I don't believe this young 30-year-old attorney. She doesn't have children. She doesn't know what's happening. Use your mediator. Sometimes it's nice to have the mediator reinforce your advice. Many times I've had attorneys who have come to me and said, look, I've explained this to them, but basically they're just not believing me. You know, they're not believing that his 401k is marital. They're just not believing me.
Mm-hmm.
So we can help with that. Again, that goes back to choosing your mediator.
It does. And I think that part of that is and it also goes into why you're there. I mean, sometimes if people haven't been to court, this is their first opportunity for both attorneys to see the other client and to watch firsthand the interaction between the clients. I think that's invaluable in and of itself, because you learn a lot. Because let's just face it, sometimes people put their best foot forward when they're trying to deal with their own attorney and may make it seem like they're a little bit more in the right than any of us are. And so when you get into a room and everyone starts talking, and I think this goes into not only picking your mediator, but telling them why but being prepared. So when you see the other person, and I've seen this happen over and over again, I'll pull the attorneys out and the attorneys are like, wow, that client isn't as much of an ass as I thought he was, the other client. Because in their minds, they had something else. That would never happen, because when you go to court, it's a different scenario. And if you start to see reasonableness when you thought there was total intractability, it makes you realize what you need to work on with your own client.
That's right. And it also knows, you know, I've learned invaluable information before I go to trial, like this person is not going to play well on the stand, or I know you think he's an ass or you think she's an ass, but she's going to come across as credible to this judge. So that can help settle your case as well.
I think it is. And that's something that you also, in going back to your mediator selection and how they do it, if they're not picking up on that and they realize, because sometimes I'll tell people, all right, if you are going on to trial, I foresee this as being a huge problem for you. Either your attitude or the way you're coming across, or maybe you're your own worst enemy. But that is, the goal is to get something settled, and that can lead to settling because they realize, and I'll tell them, I said, do you really want someone else judging the way you present yourself instead of just solving the issues that are before you? You have the ability today to solve the issues that are before you and your spouse or significant, or whatever it is. But if you go somewhere else, it's not just that, you're also it's going to factor on how you behave. And not everybody wants to
No.
be accountable for the way they behave.
And one thing we didn't talk about at the beginning is that in mediation, you can fashion a remedy that a judge can never fashion, right? For example, a judge is simply going to divide the assets in half, but maybe what someone needs is, maybe we can figure out how to pay debt without a taxable event by maybe transferring some more money through a 401k. And, we've lost some of that ability with the new tax law. But we can think outside the box in a lot of ways.
Right. And there is one, I just had one today, earlier, that basically the issue of maintenance on a very, very long marriage, but one of the people may not have had the wherewithal to probably be reliable to pay that. So in mediation, we're able to say, okay, what other, look at asset division and reducing that from the obligation so it's more palatable to the other person and maybe more attainable, so they're not having to pay attorneys for the next 5 years to enforce this agreement, because that's setting people up to fail, and that's not what you want to do. So making sure that your client understands that in mediation, if you all agree, it's going to get done. And where you go to court, it's definitely got confines, whether it's the four corners of the room or the way the judge sees it, or this, that, and the
Or
other.
the statute. I mean, they're bound by the statute.
Mhm.
They couldn't give the other party more of the marital estate and no maintenance. It would be a maintenance case,
Mhm.
right?
Right.
So there's ways that we can fashion a remedy. And the other thing is that sometimes one party looks at the case in a certain way, asset division and maintenance and blah, blah, blah. And then you go the other room and they're coming back and they're kind of restructuring how they want to divide these assets. Well, you got to be able to think on your feet, because then when you go back and say, look, they kind of looked at it differently, but let's run the numbers. It's not that far apart. They're just looking at it in a different way.
Right. And I think that happens. And everyone in the room has to be able to look at it in a different way and say, oh, really, it's 6 of one, half dozen of the other. Instead of just saying, oh, no, because they're not figuring it just the exact same order, we can get to the same result.
That's right.
And sometimes, and I will say this, and I don't really know where it fits in, I think it's how you approach it too, because even if it's an extremely document laden, information, number sensitive case, you have to make a choice at some point when you've got enough of that information on the table. Are we going to go in the weeds and possibly suffocate everyone in the room? Or are we going to take a step back and figure out, how can you come up with something maybe a little bit more broad brush, making sure that everyone still knows the components, but the components themselves can
Yes.
stifle people, I guess. And so it's just something to weigh, I think.
Yeah, there always comes that point in the mediation where, like patient says, you've been through every little asset. This is a $15,000 difference. This could happen here. This could happen there. And then basically you're $20,000 apart. I mean, basically there's some number where you're just a certain amount apart. And you might want to say, look, at this point, it's litigation cost, we'll offer this. And then you go back to the other side, like, well, what about that one little weed over there? I'm like, we're past that weed.
Mm-hmm.
We're down to, this is how far we are apart. And do you guys want to settle today?
And I think that's where you have to,
issue.
and I think that's how you have to do it, because when that you start seeing them go for that one little weed in the corner, you have to stop and say, do you all want to, is your goal to settle this or isn't? Because, like they say, bitterness binds us as tightly as our love once did. Sometimes when you get to that point, it really becomes apparent that it's a processing thing. They're not quite ready, or we need to talk a little bit more about, okay, if we get closure, how do we go forward? Because it's scary. Even if it's a bad situation, the old is less frightening than the new and unknown. And you have to address that, or you're not going to be able to go forward.
That's right. So you kind of have to get them past that little bit. And oftentimes I have to say, no, we're not backing up. We're going to go forward here. Because, all these little weeds that they just talked about, imagine trying to explain that to a judge and introducing all that evidence, and now you're in a 3-day trial. And this is how far apart you are. So, and we can never get to a 50-50 exact division, right? First of all, again, maybe the appraisals are only $15,000 apart. Particularly if you have a business, good business evaluators give you a range, that's an appropriate valuation, right? You kind of have to, after the process, let everybody vent, let everybody do their thing. And, then at some point they have to say, I'm ready to move forward. And clearly, if you have one party who is not ready to move forward, you won't settle. Usually by the time we in Fayette County, because we have really good practitioners here, get to mediation, this has been going on a while, and even the party who was shocked is kind of up to speed that this is going to happen. And usually, most of the time they want to settle, and mainly because, my line to my clients are, look, you all can send your children to college, or you can send my children to college. That's up to you. So usually they want to get settled and preserve their assets.
Right. And even if they're hesitant, their attorney who's done the preparation has told them why. Even if they're not ready, they need to get ready. And, this will happen with or without, and when you maintain some of the control on how it looks, you're part of the process, it's going to be easier to go forward. And that's part of the preparation part, I think, too.
That's right. And they're going to know, particularly the non-moneyed spouse, the non-moneyed spouse is always concerned about how can I possibly make it? So they have to know that if they have X amount of dollars, this is how they're going to crack this nut every month. This is how you can make it. Because they have to have an understanding. And if a judge just comes down with a chopping block and just says, here you go, they don't have that chance to process that.
Right. And that's another really important part, because nothing changes, nothing stays the same. So the first part of the non-money spouse coming to grips with that is sitting down with their attorney and having that empowering conversation about, all right, what are your budget? What does it look like? What are you going to do? You can have a wish list, or you can have this and that, but part of this whole process is making sure that they are prepared to have those discussions. Because sometimes you come in and their fear prevents them. It paralyzes them. It paralyzes people. And when your fear paralyzes you, you're giving up control over your whole life, because the only way it's going to happen is a chopping block.
Right. And one of my methods is sometimes, anyone who's been in my office knows I put a great big postie on my wall here, and I go through all of the numbers with, let's say the non-moneyed spouse who's going to get maintenance, right? And they're like, well, how can I possibly live on only, $30,000 a month? There they are. Huh. So, yeah. So, you just say, this is where you have to be here, and this is where you have to be here. But you can do this in this town. We all know, as long as we've lived in this town, what it costs to live here. And then if I have to go to Harlan, it's not costing that much in Harlan, right? So we all know what it's cost. And if you can walk the parties through, particularly this usually happens when they're separated, and you walk them through and say, this is kind of, where you are, and this is what you can do. And also sometimes, you have another party and the financial resources aren't there. Yeah, I need $30,000 a month, but he only earns $30,000 a year. So that's not going to happen, right? So, you have to, I like the visual aid myself. I'm big on that, that everyone knows where we are. He says the house is 250. She says it's 300. So that's where we're apart there. Just kind of go through it. Sometimes I do that too, because when people are so involved in the fight or the emotions of the situation, when I can get them focused on the numbers, they get to work. Mm-hmm. And that I have found that very effective. Like, they're so caught up in all the emotions of the day, and they're exhausted, and they didn't sleep the night before, and they're worried, and they're seeing their ex and all this kind of stuff. And when I start focusing them on hard numbers, they don't think about anything else.
I think that does help, because it gives them a focal point, and it lets them, it's easier when they have something to focus on instead of being overwhelmed by the situation they're in. So I think that they should see that before they, the first time they see those kinds of things shouldn't be in mediation, because sometimes they get really wigged out if this is the first time. It's like, well, wait a minute, I didn't know this is where this,
Right.
So it's a good tool to be prepared. Let's see. as far as like the next point on here was about confirmation for mediators. Here, it would be always nice if the clients sometimes come in and they feel like they're not informed either on what the cost is, who's going to pay the cost. We don't get involved in fee disputes, which is always kind of a little dismaying to some of them, because they'll call, I didn't know I was supposed to pay, or I didn't know. And I think attorneys should just be, if you haven't gotten a confirmation from your mediator, you should get it ahead of time. It should go to your client. Your client should know exactly what to expect time-wise, exactly what to expect fee-wise. So that's not just another, this is a stressful time for them, and we do it every day. So sometimes we become a little hardened to it, but this isn't their every day. This is, a very important day. So the more that they can know kind of what's going to happen. And I think, Valerie, you attached these, right?
Yeah, I attached to the outlines on it's on the website, an agreement to mediate that I send out in every case to both the attorneys that I expect, of course, will go to their clients. It talks about the fees and what's expected as far as that goes. And I also, and Patience, we all know Patience does this as well, is before we start mediation, I do an agreement to mediate, which includes the fees and how it's going to get paid. And of course, Patience, in my favorite part, you can't call us to court, right? So it includes all that information. I agree. And if someone's like, when we're starting this, a lot of times, they have already signed my agreement to mediate before they walk in the door. So everyone's really clear. But I'll go through it with them so that there's no surprises, because I don't want being after staying here at 6 o'clock at night and starting at 9 o'clock in the morning and someone say, I have to pay for this.
Right. And just having that ahead of time, even if they get that and they read it ahead of time, it's always good to go over, because people make fun of me because I have my little spiel that I'm sure all of you can probably quote by heart. But if I don't say that, I will get like 30 minutes in and someone will ask a question that was like clearly in my little spiel, and I didn't either about, can I record this? Yeah, no. Yeah. So this is confidential, and then I'll have to go through it again. So because it's not anything nefarious, they're not doing it on purpose, but they're kind of nervous. They don't really, this isn't their everyday. So I think it's just worth that couple minutes to go over it, because even though they may have read it before they came, they're nervous and can't see anything because they're staring at the other person that they've been with for 30 years. And,
I agree. And I think that we also assume that, I always do that as well. And I also think it is assumed that the attorneys have gone over with them. And sometimes they haven't, just because it's not how they practice. And sometimes they haven't because they've been doing it so long, people just start assuming their clients know how to go to mediation. And they just forget, when you have a whole bunch of clients, you're like, well, I'm sure I explained mediation to them. And you're like, well, maybe I didn't, right? So I agree. I think
it's easier to go over it. So then they're hearing it and it's no big deal. And sometimes it gives them a minute to realize the tone. It's pretty relaxed. It's not, because they come in on pins and needles. And if any of, for those of you that know me, I'm not a pins and needles kind of person. So, it can let everyone do the and breathe a little, which you're going to be off to a faster start if you get that than if you don't.
And I think it's important, particularly people with children, to express to them how important it is for the two of them to make the decision about their children. They do not want a stranger making a decision about their children. Maybe I don't think they're the great parents in the world, but guess what? They ain't my kids, right? So they need to make these choices for themselves. And I need them to focus on that.
Right.
While you are pausing to take a breath, we do have a question from the chat box. Eileen O'Brien writes, I can see the benefit of arbitration if it results in a faster resolution, but I don't see that it has any of the same benefits of mediation other than possible quicker access to a decision maker. Do you see any advantages to arbitration that we should consider?
That's a good question.
Hi, Eileen, which I'm sure Eileen is very qualified to answer this question. I do see that there is an advantage to arbitration because you can control so much of the process. For example, let's say in arbitration, you want to just know, if you knew one thing, the value of the house, the value of the business, you could have an arbitrator make a binding decision on that one item. And if you had that one item decided by arbitration, you could solve the rest of the case without going to trial. So that's a thought. Arbitration is also very valuable if you don't want a court record. If you do not want 3 days in a trial in front of an attorney, in front of a judge who, you don't know when they'll be done, you're going to go to the middle of the night, you can set your complete own schedule in arbitration. You can do it over days, you can do it in a short amount of time. You can also define, and it all should be in your arbitration agreement, the rules of evidence. For example, do you want to agree that the arbitrator can rely on the expert's reports without testifying? This is something that you would decide before in a written agreement in arbitration. So there's many things you can consider. Would you rather have someone like Suzanne Baumgardner be looking at business valuations than me, right? Someone who is very experienced in certain areas of the law, you might want to pick as an arbitrator. So I do think that there's a lot of advantages to arbitration.
Beyond efficiency.
Beyond efficiency. I do.
And I think that, I think the efficiency is a great, that's I think what everyone thinks of first.
Yes.
But for the reasons that that you kind of put forth on setting your own timeline, setting your own rules, there's something to be said about that too, which is out of your hand if you go to court.
Yes, and again, it's completely confidential. A lot of people don't want anyone to be able to review a court record. If the record is supposedly sealed, sometimes that doesn't work. The Supreme Court and the Court of Appeals were really kind of down on sealing those non-children abuse cases for a while, so some judges don't do it. But you control your own process and how the evidence is presented. Again, it's by pure agreement. You choose the arbitrator. Both sides choose the arbitrator. No one appoints an arbitrator. Both sides choose how the evidence is being presented.
They negotiate that, though. They're going to negotiate the framework by which they're going to submit things to the arbitrator for the decision.
That's right. And you can have a 3-arbitrator panel. You can do that if that's a concern. So you have control over the process. I think that's a big advantage to arbitration.
Good question. Thanks, Eileen.
Thanks, Eileen. I'd like your thoughts on it.
Can we just zoom her in?
Yes, we can.
She's going to wish she hadn't said that. Okay, I think the next point was about mediation statements prior to mediation. Not required.
Pardon me. I'm so sorry. Eileen actually had a follow-up question. Have you had any feedback from our judges in Fayette County about the use of arbitration?
The feedback that I have had from my judges is that they are very much in favor of it. That's the feedback that I've had from my judges. Particularly, judges say some of these cases that take 5, 6, 7, 10 days on their docket when they could have done 90 other cases instead of this one, they would have liked to have arbitration as an option. That's the feedback I've gotten in Fayette County. It's my understanding in some of the other counties, they might not be keen on it, but again, it's by agreement. No one can order it. It's by pure agreement. It just is another tool in your toolbox to settle a case.
And I think the other side is, and I think, I don't know if that's where Eileen's going to, it's still, the key difference is you're still having someone else make these decisions for you. So obviously it's not going to be, it's another option, like you said, another tool for conflict resolution, but it doesn't, it's more quasi judicial than it is anything to do with mediation and negotiating it. But if it helps, and maybe you could speak to this, if it helps to narrow, or if we can get some of these things taken care of, then they can mediate the rest, or they can come to, or maybe they don't even have to at that point. But there are some things, like there may be the issue that they're really hell-bent on needing to be told. Is that a more efficient way of handling that one issue that allows them to then sit down and do the rest of it the way they should by themselves by mutual agreement.
Right. And we've had clients do, Judge Dixon has done a couple of arbitrations on single issues for us, and it's worked very well.
All right. All right. Well, if there's nothing else from Eileen, which we would
Which
more
we-
than welcome.
Yes.
We talked about, so mediation statements. I don't require them. I think that when there is a very complicated case that is multifaceted, it can be helpful. And people just need to be clear, is this going to be a confidential mediation statement? Is this something that everyone's exchanging where they're at beforehand? Because those are two different things. And I always ask if it doesn't clearly state on there, but they can be helpful. I don't find it extremely helpful when people are arguing their case in them because I am not an idiot. And I think it's better just to kind of lay out, this is where we're at, this is where, and I'm not looking for concessions on either thing, but more of a kind of a factual thing. So that's where if it's multifaceted, maybe, hey, if we're going to talk about the financial parts, these are the pieces, just so you know that one account has 5 sub-accounts, and then there's an umbrella policy here that those kinds of things. That is helpful. But sometimes people take a little bit of liberty in creative writing.
Yeah. But just having sometimes, the first thing I do in a financial case, if I don't have anything, I said, okay, list the assets, house. And someone will say, I think the house is worth 350. And do you agree? Yes or no? I think it's worth 300. Okay, check. Next asset. If that's already done, it just saves a wee bit of time, but it's not necessary.
But I do like when they can identify what they think the big issue is. Because sometimes what's funny, if both sides give me a statement and they both disagree as to what the push issue is, like the big major issue, I'm like, whoa, we have more work than we think. Good news, that's not the issue. Bad news, this is the issue. But it does give you a little bit of a jump start.
Yeah, it just saves you a little bit of time.
Mm-hmm.
I mean, it's not like, we're not knee deep in these cases like the attorneys are. And, that's another thing about your mediator. When you live with the case for 6 months or longer, in some of these cases, 2 years, you have started down a path on these cases, and maybe you didn't see the big picture. I am so fortunate because I practice with 3 other excellent attorneys. I cannot tell you how many times we are in each other's office saying, is this how you see this? What's going on here? When you practice alone, that is really, really tough. And, I know people who basically practice alone, and they'll just call up and say, how do you see, can I run this by you? And say, sure, just sometimes just having someone look at it a different way is helpful.
Oh, I think so. Yeah. And if you don't have that, that's where it's a helpful tool just to have that kind of, because there are times people will come in, and I will be honest, because I'm coming to the party late, is that I'm like, what are you talking about? How are you seeing this? And not, disrespectful, not anything, but but these people have been living every little intricacy for this long that it's part of them. So they don't,
right.
So you either.
Sometimes you're not seeing the forest.
Right, you're missing the forest for the veins on the leaf of a tree. Yeah. So that can happen. So let's see here. What is the next part? Where are we? Oh, using the mediator.
Okay, we did that. Okay. When to stay together and when to break. This kind of also goes back to the previous one about diffuse explosive situations with clients and counsel. Sometimes it's like, if people, when I'm just going, like I just sit down, I'm just kind of going through the assets, what's going on, and all of a sudden things start to explode. I said, let's just table that, move on. And then sometimes I'm like, okay, well, we'll discuss that when we break out. So.
Mm-hmm. I allow some venting. I'm from a large Catholic family. We're used to a lot of yelling. So, some of it you have to kind of get through one way or the other. And then if we start circling around the second time, it might be time to just move on, or, okay, I see we need to talk about that more, but help me understand everything that's there. Or I'll back up a step and say, I've got to have a big picture of what we have, and then we'll go back into these little issues. So I think that's important. I think the other thing is sometimes it is more comfortable for people to be apart. However, that is not necessarily it isn't, the beneficial part of it. My comfort zone might be staying in a room and not seeing people I don't want to see, which would be great, but it probably wouldn't behoove, working things out or behaving in society in general. So I think that you have to be aware of that, because sometimes people want to break out immediately. Now, obviously, anytime there's domestic violence, we'll set it up in separate rooms, no questions, no anything. If it's not something that there's going to be a lot of long-term involvement, like maybe these people, they've been separated 10 years, they live in 2 different states, they don't have, I get that. But more times than not, for starting, so I say that spiel only one time, and just identifying the issues, because here's the thing, is sometimes when you're going back and forth, someone remembers something at the last minute, and then the other side's like, well, now they're just throwing that at me and adding that in, and we thought we hadn't agreed. Well, no, you didn't. If we were all together, when I said, all right, what are we here to talk about? Let's list them all out. Then we would have a comprehensive list to go from. And when you don't have that, it can sometimes be perceived as someone trying to sneak something in, because suspicion runs a little high in these things.
Yeah, and I've had the situation where people thought they were a part on an asset, and I said, what do you think the asset's worth? Whatever. And they say, we agree. And everyone's like, you do? Right. So great. So, I do like to try to start together if at all possible, and especially if there's children, they've got to talk about their kids. Right. You guys had these children. You're going to have to figure this out. But I do like to, even if we're not going to get to an offer, just at least get everybody together to list the assets and discuss the issues we need to discuss. I like to have that done.
Right. And I think with parenting, it's crucial, because most of the time, those cases are, when they're referred or recommended by the judge, whatever you want to call it, it's because they want these people to parent their children. Well, I know from being a parent, it's easy to parent them the way you want to if you're only taking the input of one person, being yourself. So that is a huge thing to overcome. And even if it's, I think that's what you have to rely on your mediator for too. I don't let anyone beat up on anyone else. Now, I might tear them both apart, or challenge. That's a better
challenge is the word I use.
I need her for my euphemisms, because obviously tear apart wasn't what I was going for. But I mean, the challenging part on both sides, non-discriminatory, I'll do just out of what makes sense. But I think that when you don't have that, you're not going to, they need to learn to co-parent, and which means they need to learn to talk. And it's always funny when you ask them, oh, we communicate fine. And then, 5 sentences later, well, did you know so-and-so went for the appendicitis? Well, I thought that wasn't appendicitis. No, you obviously don't communicate well. So I think it's really important when they're kids, because these people need to be accountable and just raise their own children. And everyone's going to raise them differently. I raise mine differently than she raises hers, and that's fine, but they have to work on the same page. And if they don't, sooner or later, they're going to do it, or they're going to end up going to cooperative parenting or parent coordinators and then those are all great tools, as long as they're tools and not a life coach. People need to be responsible for raising their own kids.
And then they do it again, and they still haven't got it figured out.
And it's easier sometimes, even if they're getting beat up on both sides by the mediator, it's easier, and that's still not the answer, because I don't need any more children.
Yeah, me either. So let's see. Knowing when to mediate, I think we did I jump ahead? Go ahead.
One more thing. I do think there are times for processing. And I just wanted to add this, because it just happened not long ago. It was clear that people were processing differently. So we took a break under the auspices that we're all coming back together. And that's, there are times of caucus period when we're just going apart. But there are some times where you can just say, hey, and attorneys should just say, hey, you know what, I need a minute. And we can caucus for a minute, and then we might be able to get back together. So always kind of leave the door open, because if it's not the thought that you're never going to be back together, it's more palatable, even if you never come back together. Just leave that open. Let's just spread apart for a minute. There's a couple things I want to go over, but leave the door open that you might, go back into a joint session.
And the same on the other foot. Let's just get together so I do my spiel.
Yeah, I do.
And, so, I just start them together with the intention I'm not going to spread, divide them up real quick. Both ways.
Yeah. It works on both sides.
Yeah.
Okay.
We kind of talked about when to mediate. Again, remember that maybe your mediation is to get a Band-Aid on it for the next 2, 3, 4 months and move on with how you're going to do your discovery and what needs to be done.
And you know, that Band-Aid thing is important because people are so, the fear, kind of like anger comes from 4 core emotions: fear, frustration, disappointment, and hurt. So any of those core emotions going without being addressed rises to anger, which is what all these practitioners are seeing all the time. So even if you can get in the door to mediate and get some temporary Band-Aid type things, it's amazing what that does for your clients, because they're like, oh my gosh, we did work this out. Well, if we worked this out, because they're fearful and they're going to tell you 10 ways to Sunday how it's not going to work out. But if they do that, and they do it even for the 30, 60, 90 days, then sometimes they can, do it without coming back to mediation. They just learn that, and you do more of a quasi settlement agreement situation with the 4, counsel and clients. And so it can be really valuable from that standpoint too. A little success goes a long way.
Yeah, I agree. And gets them off on the right foot, and again, particularly when you've got an attorney on the other side that you don't know, or you don't know what's happening. Some of us old folks like Miss Eileen and I, we can say, look, we got to get these people off on the right foot. And sometimes we can do that without a mediator. But sometimes I have an attorney who's not real experienced, and I'm just going to have to go into mediation to get some of these temporary agreements done. It's either 10 minutes in motion hour, right, on temporary motions, or
Right.
we can try to get it done in the mediation.
Mm-hmm. And then sometimes that leads to, all right, well, what do we need to get it all done?
Right.
And you're further along, which is beneficial to them. All right. What else?
Are we to the Scribners?
Sure.
Okay, so I always try to come to, if I'm working on a full-fledged agreement, first of all, I've tried to already send something to opposing counsel if at all possible. And I always try to at least show up with my, form separation agreement, with blank on the house and blank on the maintenance, so that I don't have to spend another hour with patients doing a full agreement. So sometimes that works. A lot of people are very familiar with my agreement. I think a lot of our agreements are very similar. Sometimes the other side, like, she drafted it, I don't want to have anything of it.
Mm-hmm.
You patients needs to do it. Okay. We'll sit here another hour. And then, the other thing is, again, sometimes when I'm here till 9 o'clock at night mediating, and we finally have the bullet points, sometimes I just do bullet points and make everyone sign it. That can be dangerous, but generally I do enough cleanliness in the bullet points that it's pretty clear what's going to happen.
Mm-hmm. I think that when people come and they've already been working on an agreement, as long as both sides have it, I think it really sets us back. If, like, you do a great job of, I've been working on this, there's kind of blanks in here, I already sent it to opposing counsel, cool. But when opposing counsel doesn't have it and they feel like they're bombarded with it, it feels like at those times we'd have to step back and be like, okay, wait a minute, that's the times when then they want to scrap everything, which really, if they looked at it, they would probably see it's very similar to their agreement or anybody else's. I tend to I like to have things signed before we leave, because in my experience, when it isn't signed before us leaves, all kinds of things. People hear different things, they see different, I start to wonder, was I in the same room with everyone? It's very confusing. But there are times, and any of you that do the motion hour ones, we write them. We just literally hand write them, because we want to have, you need the speed of doing it. It's usually a Band-Aid situation, but it's important that they have something that when they leave, they're like, this is what I agreed to. Because I think that's the other key, is if the parties have something that they can see that they've done and they've bound themselves to, because that's really what we hone in on. If you sign this, you're agreeing you're abiding by this agreement. And I think that's important. Some people are real bent on having the mediator do it. I don't care one way or the other. If you're drafting and you're going to try kind of use it in mediation, and you're drafting as an attorney, just remember the other person is going to see it with a bit of scrutiny. So I'm always real honest. I'm like, don't be putting stuff in there, sneaking stuff in there one way or the other. I think the other benefit of, even if you're going to do that and then having that clause in there saying that I'd like to have a clause in there that says it was drafted in mediation, because at that point, I don't want it to be on one attorney or the other. If we're taking a template and we're then saying this is drafted by both counsel and the mediator in mediation, I think everyone feels more comfortable about that.
Yeah, I think that's fine. I've been in late night mediations where I have had parties sign the spreadsheet
I've done that.
and it had every asset and how it was divided, because it was going to be a 30-page agreement, right? And so I have had that happen, and then either I have then finished the agreement if I'm the mediator, or the attorneys are familiar enough with everyone that one of them will do it, and they can take off with it.
Right. I remember one that I had, it's kind of funny, but I have one of those big boards, and it was late at night, and some of them were in from Louisville, and we'd had most of it done, and we were signing, like you said, spreadsheets, everything else. I ripped that off and folded it up into a little piece of paper and make everyone sign. I agree to everything that was on here. Because to keep them for one more hour, I probably it could have gone the other way really quickly.
Right. I want
So,
something signed, even if
But
it's a bullet
everyone
point.
signed it, and it was the biggest, piece that we could find with the remaining assets, and it was
Right.
just kind of, so anyway, however we need to get it done, just make sure it's memorialized somehow. Yeah, I think that's important. The whole one's about nothing on paper. I think that's a terrible idea, but that's just me. Do you agree?
Yes, absolutely. I like to have the Big Mac Daddy if possible, but I have done some Band-Aids. I got to go pick up the children.
Oh, we're out of time.
I think we're close to out of time. Anything else?
I'm not seeing any additional questions in the chat box. To speak on behalf of Courtney and Caitlin and all the participants who are watching this, thank you both. This has been very illuminating and helpful to know some of the best practices that will help our clients get the most out of your time and the money they spend for your time. And I'm particularly grateful to have some of those practice tips that I can then use to enhance the work that we do with you. So I want to thank you both for taking time out of your busy days to give this presentation to the domestic relations section. And I really look forward to working with you both in the future. Thank you so much.
Thanks, Courtney. Thanks, Caitlin. Have a great day.
Thank you all. And the CLE sheet is on the website, and this will be up on the YouTube as soon as it's downloaded. Thanks, guys.
Thank you.
Thank you. Bye.